Yeah. Welcome to the Equal-Opportunities-Committee, the 23rd meeting of 2013. Please set any electronic devices to flight mode or off, please. I'd like to start by getting everyone introduced. At the table we have our clerking and research team, together with our official reporters. Around the room we are supported by Broadcasting Services and the Security Office. And welcome also to the observers in the public gallery. My name is Margaret McCulloch and I'm the committee's convener, and I now invite members and witnesses to introduce themselves in turn, starting here on my right.
I'm Marco Biaggi, I'm the Deputy Convener of the Committee and I'm the MSP for Edinburgh Central.
Alec Johnston, Member for North East Scotland.
Good morning, John Ferry, MSP Highlands and Islands.
John Mason, I'm the MSP for Glasgow Shettleston.
Good morning, Siobhan McMahon, MSP for Central Scotland.
Good morning, Christian Allard, MSP for the North East of Scotland.
Kelly Coleman, University of Glasgow.
I'm Aidan O'Neill, QC. I'm a member of Matrix Chambers in London and I also practice in Scotland. I practice, I suppose, in EU and human rights law and have a particular interest in the relationship of law and religion.
Lynn Welsh, I'm Head of Legal at the Equality and Human Rights Commission in Scotland.
I'm Karen Monaghan. I'm also a barrister at Matrix Chambers, specialising in equality and human rights law.
Okay, thank you. The only agenda item today is an evidence session on the Marriage and Civil Partnership Scotland Bill at Stage 1. Can I start by letting our witnesses know that they should indicate to me or the clerk on my left when they wish to speak? And welcome to our first panel of witnesses. Who have I got? Marco Biaggi on my right will actually start asking the questions.
Thank you, Convener. That's quite all right. The first question concerns the opt-in protections that are in the bill and more broadly whether any attempt on human rights grounds to challenge a faith group that had not opted in to performing same-sex marriage to require them to opt in would succeed or not. Ms Monaghan, I already have your opinion on the record on this from what was applied to Liberty, but I'd be grateful for the other two legal views.
In short, the opt-in, we believe in the Commission, will work and will not be open to human rights challenge. Obviously, someone can challenge it, but they would not, we don't think, be successful for many of the same reasons as already set out by Ms Monaghan.
Mr O'Neill? I never like to say that a human rights challenge won't be successful. There is a difference, has to be said, constitutionally between the position in England and the position in Scotland in terms of the relationship between the Church of England and its effective position as it used to be the Department of Marriage for the English state. And so at some levels there are arguments to be the effect that the Church of England is a public authority when it carries out marriage functions, because it has a duty in law to marry anybody, no matter their faith, within their parish boundaries, and that is not a matter of church law, it's a matter of the common law of England and backed up by the statutes which created the Reformation. In Scotland it's different, it has to be said. We have a different relationship between the church and state. The Church of Scotland is not, it never has been a department of the state. We've always had a notion, that Calvinist notion of a separation of church and state, and marriage law has always been, has a completely different history in Scotland. So I think the arguments which are perhaps more plausible within the English situation are less likely to have as much sway in relation to Scotland, because the Church of Scotland is not, it cannot be seen in the same way as the Church of England to be a public authority.
So do you then consider that Article 9 would be a strong protection for a church against a challenge on that basis?
Yes, Article 9 is sort of a rather overlooked provision within the context of the European Convention on Human Rights. That says there's a right to freedom of thought, conscience and religion. Those are absolute rights. And then there's a right to manifest the religion either in public and private, in worship, practice and observance. That right to manifest religion can be modified if there are good reasons for that or can be subject to interference. The other rights of freedom of thought, conscience, and religion cannot. So yes, there would be quite a hurdle and a strong protection in terms of Article 9 if churches can prove that they are not part of the state, and that's the issue. That's why there's a possibility in terms of the Church of England because of the peculiar status, and also, as we said, the Church in Wales that also has a duty to marry anybody within its boundaries. So you then get the paradox that in England a church-going, believing same-sex couple who have been attending Anglican parish services throughout their lives would not be able to marry, whereas the twin brother who's never crossed the church door in his life would have an absolute right if he just happened to be marrying a woman rather than a man.
Dr. Coleman, are you aware of any challenges in other countries where there are similar protections for religions to opt out that have sought to require religious authorities to perform same-sex marriages against their doctrinal views?
Well, as I've said when writing and responding to this invitation, I'm not a legal scholar, so I don't know the ins and outs of any kind of legal challenges. What I would say is that there has been controversy in some of these other countries, exactly where there have been religious celebrations, particularly where the church can do marriages with legal effect. But these have died out relatively quickly, and I certainly know of no case where they have been forced to do so. And in fact, in the countries, the Scandinavian countries in particular, where they've opened marriage relatively recently, and where the churches do have the ability to marry with legal effect, these similar types of opt-outs and protections for the churches. Most of them have opted in, actually, but they do allow people to opt out, and as far as I understand it, that has worked relatively well.
Can I move slightly on? If anybody else wants to come in on this would be a good time.
Well, could I just ask Dr. Coleman on that point? It's been suggested that in Denmark there's not the freedom of the churches to opt out. Is that the case?
I've heard this in several cases. I mean, Denmark, I'm going to qualify this again, it's not one of the cases that I have studied in depth. But my understanding, having looked at that case, that there are, in the law, there are protections. I think most of the controversy that I know of that has happened was when the church itself decided that it wanted to do blessings, right? Which was not part of the original legislation that was passed in '89. That there was a lot of internal controversy within the church, and there was a fair amount, there were a number of members of the church that were not very happy with these blessings. But as far as I know, when it came to marriage, that controversy was far less.
Thank
you. Can I come? If you're coming on this, yes.
Simply again on the dairy situation, as I understand it, in Scandinavian countries, the established church, the Lutheran Church, was very much seen as a department of state in the way that the Anglican settlement was, and that you have a minister in government who's in charge of church affairs. So there's a different kind of relationship from what traditionally would be the case in Scotland, and particularly as the Church of Scotland is not an established church, it's the national church. It's recognised as such, but it's under the Church of Scotland Act 1921, but it is most certainly not a department of state. I mean, that would be completely contrary to the whole Reformation settlement and Calvinist ecclesiology.
Christian Allard.
Thank you very much. That answers part of my question I was going to ask. I'm quite interested about the relationship between states and church. Is there same kind of relationship in other countries who have accepted same-sex marriage, who have a church who is linked that way, like the British way or the Danish way, with the churches?
Again, I think the Scandinavian countries are the only ones which have that similar kind of what's called an Erastian settlement, whereby at the time of the Reformation, it was the king or the monarch who decided what the church should be, and it was subordinate to it. The Reformation in Scotland was different because it was against state authority. It was against the wishes of the reigning monarch at the time, Mary Queen of Scots. So it was a different relationship. There aren't very many countries that have that, as it were, a national church, which is absolutely and fundamentally separate from the state. I can't think of them.
Just as a point of reference, Sweden is the one Scandinavian country that's de-established its church, actually, just so it's not all the Scandinavian countries.
So I just wanted to come back on this. So on a legal basis, in your opinion, would it be the biggest problem, if it is a problem with the bill, is the relationship between church and state more than really the equal marriage?
Yes, I do think that's a problem. There is, and this is probably possibly anticipating an issue which may arise, but one of the issues which this bill does rather unusually is it purports to give to dissenting ministers of a church which has opted in the option of opting out themselves personally, even although their own church has decided to opt in. That doesn't seem to me to be possible. That seems to me to be a breach of Article 9, actually, that an opting-in church can decide what it wants, and it's not for the state, it's not for the Parliament to say, but we are going to allow its individual ministers to exercise some kind of individual freedom of conscience against the wishes of the church body itself. That's a peculiarity of the Scottish legislation, and that is the one thing which I think is problematic about it on that church-state relationship.
Can I bring Karen Monaghan in, please?
To agree with Aidan on that point. I think that does create a difficulty. I mean, Article 9, of course, protects religious organisations, churches, as well as individuals, unusually for the convention rights. It protects institutions. And I think there is a difficulty in saying that an opting-in church is required as a matter of law to permit a minister to exercise, if you like, a conscientious objection to carrying out same-sex marriage. That's really a question for the religious organisation, the church itself, not for the state. And so to the extent that there's a vulnerability, I think that's where it lies.
On that, how does that work for denominations such as, off the top of my head, United Reformed Church or the Unitarians, who have no specific creed in a lot of areas and may, for example, as a matter of their faith, wish to allow the decision to be with individual ministers? Is there a distinction between that and, for example, the Quakers who wish all celebrants to perform same-sex marriage, having one of their celebrants objecting?
Yes, I think so. I mean, I think if it was the church itself or the religious institution itself that said it's a matter of conscience for all of its ministers, then that would be permissible. But it's where the state requires, or permits rather, an individual minister, contrary to the wishes of its own church, or his or her own church, to opt out, if you like, individually, notwithstanding that the church has opted in.
Thank you. Can we move on now to John Mason?
You're coming to me next, right?
Yes.
Thank you. Mr. Neil, you had previously given advice, I think, on this subject, so I hope you don't mind if I refer to that. I mean, you talked about in the Equality Act that there's no hierarchy of protected characteristics, but that some characteristics are more equal than others. Could you maybe expand on what you would mean by that?
Clearly I was quoting George Orwell. I think it's one of those unresolved issues in the Equality Act, that there's a bit of an omnium gatherum of various protected characteristics which range from, as you know, it's rather difficult to count. Sometimes it's 6, sometimes it's 7. And in theory, because they're all lumped into the same act, they're all said to be equally worthy of protection, and that there is no hierarchy, and we just don't but this idea that there's no hierarchy is rather difficult when the two rights apparently come into conflict. The problem is the European Court of Human Rights has, in its case law, when it's faced with a particular issue, for example, it's growing development in terms of sexual orientation. It started using the language that you would have associated with the US Supreme Court. It talks about you need particularly weighty reasons. Initially, it's to discriminate on grounds of sex. Then in subsequent case law, it was you need particularly weighty reasons to discriminate on grounds of race. Then they started applying that to sexual orientation. But at the same time, they've also applied it to religion. So there are always heavy phrases going around, and it's not entirely clear as to well, what happens if there is a conflict? I suppose my concern is that I sometimes think, and this is perhaps where Lynn Welsh and myself would part company, I sometimes think that religion is, there isn't a feel for it within equalities law, that religion has somehow got in there, and the problem is that one can understand the idea of people saying, you can't discriminate against me because of my religious faith, because, you know, sectarianism in Scotland, because I'm Catholic, say, or whatever, and that makes sense. But on the other hand, if you've got a religious faith which says, in conscience, I feel that there is a distinction between heterosexual relations, married relations within an opposite-sex marriage, and same-sex relations, and that's what my religion tells me, then how do you not discriminate against a religion which at some levels could be said to be discriminatory in its intent? And that's the big problem with equalities laws. It's never really faced up to that yet.
And as you're feeling, and I'd be interested in the other members as well, but I mean, up to date, when the courts have faced that kind of choice, either the courts in Scotland, the UK or in Europe, between sexual orientation and religion, I mean, the feeling amongst religious people is that religion normally comes off worse. Is that just their mindset, or do you think that is actually the case?
I think, at the moment, I think that we're still feeling our way, and I think that the court judgments have not been particularly good on terms of the religious front, but part of the problem with that, I think, is that most of them have been English cases, and the English approach, as I've said at the start, in terms of that, as it were, residual Anglicanism, is that the state tells the church what to do. So they're used to the idea of religious beliefs being subordinated to the general law, which isn't necessarily what religious beliefs themselves think about. Certainly, as I said, the Scottish tradition is completely different. The Calvinist tradition of two separate kingdoms, of the religious having integrity and being worthy of respect within its sphere. So I think it appears that there has been a sort of deafness to what it is, what makes a religious view important for the religious. And the problem is they are then sort of bundled up as being, well, effectively your views aren't really worthy of respect because ultimately they're homophobic, and if you're homophobic, then clearly, possibly, you're probably racist, or you're sexist, or whatever. And it's rather difficult for the religious to try and explain that it isn't quite like that, or it certainly doesn't feel like that, and to have labels like that is not really appreciating that religious worldview which they try and articulate, and which they hold on to, and actually which was, paradoxically, you know, a fairly traditional one for the past few hundred years, if not the occasional millennium. So there's a mismatch, I think.
Okay, that's helpful. Thanks. Ms. Monaghan?
Just to say that the idea that somehow religion has been subordinated, if that's the message that Aidan's trying to convey, I certainly wouldn't accept that. Much of the carving out, if you like, how to manage the conflicts has already been sorted out in the Equality Act itself. So, as you'll know, there are numerous exceptions protecting religious organisations more broadly than the church, religious organisations more generally, permitting them to discriminate, if that's the word we're using, against sexual minorities and indeed against other groups in certain circumstances, those who've undergone gender reassignment, for example, where that's in conformity with their religious beliefs. So much of the carving out, as I say, has already been done in the legislation. And it's also right that domestically, in our law, religion is given very particular weight. The Human Rights Act, as you'll perhaps know, requires courts to have particular regard to religion. So to the extent that one can see any prioritising or hierarchy, and I don't accept there's a hierarchy, but to the extent that one can discern one, actually the exceptions lie in favour of religious organisations. So I think it's perhaps oversimplistic, if Aidan's suggesting this is so, to suggest that religion is in some way subordinated. I certainly don't accept that.
Just to add, I would agree with Karen, unsurprisingly possibly. I think there was an awful lot of thought given when the Equality Act was being created about religion and a recognition of how there may be conflicts in the future and an attempt to avoid and make clear how that should all work. Now, you can never legislate for every position and everything that happens, but I think there's been a real attempt to ensure that there is balance across the legislation.
Could I just press Ms Welsh on that point before I mean, I was on the committee that dealt with the Equality Act at Westminster, and the government at the time refused to say that all protected characteristics were equal. So actually, the legislation has not dealt with whether there's a hierarchy or not. Is that not the case?
No, I don't.
It's left,
you may be right that they wouldn't say they were equal.
The legislation has left it up to the
to
courts, really, to decide if there's a hierarchy or not.
No, I don't think that's right either. I think the intention has been in the Act to ensure that all of the protected characteristics are protected and given specific protection in certain areas, as Karen has set out.
But you would accept
recognising that perhaps there needs to be more protection, possibly, where two areas may come into conflict. I don't think there was ever any attempt to put them into any kind of hierarchy now. But
you would accept at least that the Act does not say they're all equal, or it doesn't make any reference to that at all, really?
No. I beg your pardon, I'm sorry. So, excuse me. No, it doesn't. But what it does do, as I say, is create exceptions in respect of particular characteristics, like religion, for example, where Parliament's decided that that's necessary to accord appropriate respect to religious organisations, for example. I mean, there are many other exemptions in the Act addressing other protected characteristics, gender, for example, in certain circumstances, where, again, Parliament's thought this is an appropriate space for allowing discrimination, whether that be in gender-specific organisations like domestic violence facilities, for example. But certainly it has carved out pretty wide exemptions for religious organisations without addressing in terms the question whether there is some hierarchy.
I just want to make a more general point. I would hate to leave the impression here that the European Court of Human Rights has worked its way through sexual orientation, particularly as it pertains to family policy. It leaves large room for states to decide how they want to recognize same-sex couples. There are very, very few mandates from that court or within the interpretation of the European. I hate to, again, to get in the middle of lawyers' debates here, but I think there was an impression that Mr. O'Neill left, that there was strict scrutiny with sexual orientation in the US Supreme Court and the European Court of Human Rights, and I think that's absolutely not correct.
Sorry, 2 points. There isn't strict scrutiny in terms of sexual orientation in the US Supreme Court. And there are developing cases before the European Court of Human Rights. At the moment, the jurisprudence of the Court of Human Rights says that it is still lawful for states to prefer marriage, opposite-sex marriage. It is not contrary to the Convention to do so. But of course, if one extends marriage to same-sex couples, then it becomes a requirement of human rights that then there be an equality of treatment and regard. So that in a sense is what is important about this bill. It is actually shifting the position there. On the issue about religious organisations being protected, the argument is always put forward when a religious organisation tries to rely on the protections of paragraph 2 of Schedule 23 to the Equality Act 2010, is that this has got to be interpreted as narrowly as possible because you're being allowed to discriminate. And also, there isn't any provision for religious individuals, people with religious conscientious objections, religious organisations. So I wouldn't say it's... I think the Equality Act leaves open the possibility of conflict and doesn't necessarily answer all the concerns of those who consider themselves to be religiously motivated.
Okay, thanks.
We'll move on to the next question.
Just simply to say, Aidan O'Neill's said that once we introduce, if that be so, same-sex marriage, then the position in the European courts will alter, because then we have marriage for both groups, and the expectation will be that there will be equal treatment. That's so, in my view, prima facie, but again, the question whether or not that will intrude upon the rights of a religious organisation under Article 9 will be a significant question. And again, as I've said, in my view, Article 9 will be given particular weight. So even in circumstances where the state legislates for same-sex marriage, it is extremely unlikely, indeed I would go so far as to say inconceivable, that the European Court would say that religious organisations therefore must conduct same-sex marriage even if they find it objectionable because of religious belief.
Okay, thank you. And can we move on to Christian Allard?
Yes, I would like to ask a question to Kelly Coleman particularly, and other witness can add to it if they wish to, is regarding the other countries who adopted the policies of same-sex unions in recent years, and particularly the pace of policy change. And I want to talk about the pace of policy change. I want to talk about the pace, how the bills came to fruition, and were there enough consultation in different countries, and did the process to bring the bill to fruition caused any problem? You know, some countries went faster than others. To the process. So is there any views on this? Is what I would like to know from reading your paper.
That's a good question. I mean, the general process has been that, well, I mean, there's so many different countries now that it's hard to kind of categorize or say, you know, paint with a broad brush. But I mean, generally, the countries that went earlier probably had more controversy around it. But it was the case, I think, in almost all countries, there may be a few exceptions in here, that a majority of the public supported it when it happened. These have tended to be very, very high-profile debates, high-profile policy processes. I think that means that they've gotten a lot of scrutiny, both in the parliament, but then also in the wider public debate. I mean, it's amazing to look at the media coverage, for example, of same-sex unions in some of these countries as opposed to anti-discrimination laws that included sexual orientation. And the amount, you know, the number of newspaper articles on same-sex unions or same-sex marriage is, you know, 10 times in some of these countries. It's just something that has a lot of symbolism. It tends to be something that the media covers a lot. It tends to be something that therefore, I think parliaments do scrutinize a lot. And then in terms of, has it caused problems in countries? There's always, you know, opposition. Oftentimes it's from religious organizations that have a particular cultural definition of marriage and feel uncomfortable about it. But in almost, and I've looked at this in most of the European and the two North American, well, the one North American country that has a national law. And I think with one exception that public opinion and tolerance towards homosexuality has increased after same-sex unions come in, about a year or two afterwards, rather than decreases. So in that way, if you know, I wouldn't say that's necessarily causal always. There's generally long-term trends towards increase in intolerance towards homosexuality, but I think it has brought great visibility to LGBT communities, and in general, it's been positive visibility.
So, in your experience, do you think, because reading your paper, I didn't get the answer, do you think it's more people-led, or more maybe the institutions, the European courts and other institutions led, or parliaments led, the changes, to bring back the changes?
By people-led, do you mean social movement-led? Yeah. Social movements have played a very important part in this. Having said that, I mean, it is the case that when you open marriage to same-sex couples, or even, certainly in the early years, same-sex unions, it is the case that it brings governments a great deal of attention. And generally, as I said, it's been quite positive attention. So it really depends on where you're looking and what countries you're looking. Spain, it was seen as something where a new government came in. It wasn't necessarily expected to have won that election in 2004, and that was seen as being a very government-led one, although, of course, the LGBT groups were there on board as well. But if you look in places like probably the Netherlands and Germany, where it was really kind of well, the Netherlands, actually, the Labour Party supported it quite a bit. But in Germany, the SPD, the Social Democratic Party there was much more reticent. It was really the minority Green Party. And there, I think that was much more grassroots. So that kind of depends. But it's always been a very public debate in any country that you've looked at it. And therefore, I think there has been a lot of public scrutiny and a lot of involvement of public groups on both sides. In that way, actually, I think it's been a good debate. It's been one that has been, I think, aired in most of these countries. And you know, and as I've said in the paper, I think maybe this is the point that you're getting at, that you know, this is one of these things where I think the international realm has been very important, but it's one in where it hasn't really been led by legal mandates. Politics sometimes matters, and here, what I really think matters is the power of human rights arguments, and they get translated in different ways. I know in the UK it's often talked about equalities, but or anti-discrimination, or equal treatment in different countries. But ultimately, at this point in history, I think the power of human rights arguments is really quite transformative, and much more transformative than legal mandates from international courts or EU policy. Or, yeah.
Can I actually bring in Marco Biaggi?
Yeah, just on this issue, your final comment in the paper that you sent in was about the different approaches that have been taken towards civil partnerships, or the equivalent arrangements in other countries in Europe, and you said that the only way to achieve a real equality would be to either open them up to mixed-sex couples or to get rid of them entirely. Could you expand on why that's the case?
I don't think I quite said it that way. What I was trying to say anyway, and perhaps I did say it a bit stronger, but basically, if you have a same-sex union that is not marriage, right? And this was something that was seen as politically expedient in a large part of the late 1990s and early 2000s. But most national LGBT rights groups would always say our ultimate goal is marriage, right? And that was largely made on equality issues and equality arguments. But I think what gets lost in a lot of this debate sometimes is that certainly if you go back in history and you look at the Scandinavian countries, part of what was going on was a pluralization of family policy. That is that the ways in which people live their intimate lives these days has become much more complex and pluralistic, and you know, and there was all this talk about about different ways of state defining and recognizing couples, and that is of course a different issue and different argument than the equalities one, and in some ways, you know, this discussion and debate that we're having about same-sex unions can allow you to look at both issues, however. And I think if you want to do that, if you want to open marriage, I think that helps solve the equalities issues between same and different sex couples. But in doing so, and especially if you've had another same-sex union before, another type, a non-marriage type, that then you might want to start thinking about, okay, well, what about this other side of the debate about pluralizing family policy? And there, if you open marriage but then close off civil partnerships, as it would be in this country, I do think that you might be going against that second part of it, which is pluralizing family policy. And I would encourage all parliaments to think about that second goal as well, as some have done, obviously.
Very quickly.
Can I ask very quickly the legal views on whether maintaining civil partnerships for same-sex couples only might be subject itself to challenge? Or rather, I know it's already subject to challenge, whether such challenge would have merit.
This is part of the debate which I really don't understand. In that I'm in a civil partnership. I hadn't realised it was a second-class relationship until Equality campaigners told me it was. It gives you, as I understand it, it gives the complete, well, and I should do because I'm in one and I'm a lawyer, the complete rights, exactly equivalent rights to marriage. It just doesn't call it marriage. Not calling it marriage gives those who would dissent from this some kind of wiggle room. And at some levels, it was a compromise, but it's a compromise in favour of tolerance and pluralism. So the issue of equality requiring that one rename relationships as all being marriage is, or then having opposite-sex civil partnerships. I don't understand what the difference is between an opposite-sex...
My specific question was whether an opposite-sex couple who felt aggrieved that they couldn't enter a civil partnership could challenge that?
Well, and I'm trying to say I don't see how they can, because an opposite-sex civil partnership is a marriage. I mean, that's...
Ms. Monaghan?
So you're changing the name of it, but the legal consequences are exactly the same.
Actually, the legal consequences are not quite the same, because very importantly for many couples who've been together for a long time, there is a significant exclusion in relation to pension benefits. And that's very important for people with valuable pensions who may have worked for a very long time. But leaving that aside, yes, of course, I think somebody could challenge the unavailability of a civil partnership for an opposite-sex couple. I think it would be very unlikely to succeed, because the state has a very wide margin of appreciation in this area, and because there is, for an opposite-sex couple, no material distinction between a marriage and a civil partnership. That is, they can marry and get all their pension benefits. I think the courts would say this is an area where the legislature has some margin of discretion.
Could one of the witnesses maybe answer this question? The Netherlands, Belgium and France have all kept their non-marriage schemes in place. Could you confirm if they're comparable to the one we have just now in the UK?
The registered partnership schemes, they differ quite a bit, actually. The Netherlands was relatively comprehensive in terms of the rights that it gave different sex, non-married couples and same-sex registered partnerships. The French PACS is much less comprehensive in terms of, it's easier to get into, it's easier to get out of, and a lot of the benefits and duties and obligations that are associated with civil marriage in France are not there in France, so they differ.
Okay. Ms. Monaghan? Okay, no. Okay, thank you. Can we move now on to Siobhan McMahon?
Thank you. This is a question to Lynn Welsh, firstly, but if anyone wants to comment. It's about the equality impact assessment that has been carried out when the consultation was going forward. The Scottish Government had carried it out. And it says that any assurances cannot be guaranteed at this point. Do you have a view on that?
I think it's honest, and I applaud them to that extent. I think it's an honest comment. That's what equality impact assessments are supposed to do, is to gather all information, positive and negative, and recognise that and attempt to mitigate where they can. And I think they are obviously attempting to mitigate possible difficulties with the changes to the Equality Act, for example, and the opt-in processes.
Absolutely, but do you not have concerns, because your submission to the committee was more leaning towards same-sex couples rather than the protections for religious groups, and the concerns were there. I think even in the submission, one question was missed about concerns that you had. So I'm just wondering, is the Equality Impact Assessment, have you specifically, or indeed the group, looked at that in specific depth for both sides of the argument, because the submission doesn't make clear that that's the case?
When we drafted our submission, yes, we considered the issues both for churches and for people of various sexualities, if that's what you're asking. Is yes, we looked at both sides of that, and we think that as far as it's possible to do so, both sides have been.
Okay, thank you. Back to Mr O'Neill, I'm afraid. Your submission, which I think was, the one I have anyway, was drafted before the final bill was put in place. So some of my questions may not matter just now, but if you could let us know. But it says that details about the impact of freedom of conscience in the workplace, in schools and other areas of everyday life have been overlooked. Do you still think that that's the case?
I don't remember writing that, but it's all been a long time ago. It's not that they've been overlooked. I think it's just that this notion of freedom of conscience as an individual right, that is one of the rights which is an individual right in Article 9, is not something, I think, which the legislature generally has taken on board, or even the courts, because it's a slightly odd position. Conscientious objection, in a sense, saying that some individuals say, I'm sorry, I cannot, this law at some levels, this general law, shouldn't apply to my particular situation. In Canada, what they've developed is this idea of, can you get some kind of reasonable accommodation between competing views? And the legislation and the courts allow that. They say, look, what's happening in this specific situation? Is there some way that people can rub along while still disagreeing. And I don't think our legislation does that. There's an element of, this is the law and you all have to obey the law, and there isn't, as I say, wiggle room or even the possibility of just letting things be, which at the moment, because there is a differentiation between marriage and civil partnership, and because the European Court says you are allowed to favour opposite-sex marriage at the moment, there is, at least in theory, that kind of wiggle room of allowing people to maintain their particular views, even if they differ.
There certainly has been a great deal of case law, domestically and at European level, on the question whether or not conscientious objection or individual objection to certain rules should be permitted in circumstances where they derive from religion, those beliefs derive from religion. There's been a lot of case law. Indeed, there's been recent case law from the European courts. And the way we deal with it domestically is to say that if somebody objects to a particular rule which disadvantages them because of their religious belief, they don't want to conduct a civil partnership, they don't want to comply with a uniform rule that prohibits them from wearing a cross, for example, then that should be accommodated, whether it's described as reasonable accommodation or not, then that should be accommodated unless the restriction is justified. So you'll probably have heard of the recent set of cases in the European Court where two women objected to a uniform rule that prohibited them from wearing a cross. One worked at British Airways checkout, one worked as a nurse. The British Airways checkout worker was refused permission to wear a cross because it conflicted with the corporate image. The other worker was a nurse, and the prohibition on her wearing a cross was for health and safety reasons. It might get caught and so on. The European Court said the BA checkout worker should have been allowed to wear her cross. There was no good justification for prohibiting it, just commercial uniform reasons. The nurse, on the other hand, there were good reasons. There was justification for prohibiting her from wearing a cross, health and safety. So these have already been worked out. There's a recognition that religious belief and how that's manifested through dress, expression, and so on should be accommodated unless it's, some interference is strictly justified. That's as a matter of domestic law and at European Court level. So we've got much guidance from the courts on that.
John Mason.
It was when Mr Neil said he talked about wiggle room and a bit more scope in some countries than others. I mean, we didn't seem to see that wiggle room with the Lillian Liddell case, who was registrar. We do seem to have it in abortion, though, where specifically it's in the legislation that an individual can opt out, although the state is providing the service. I mean, is that a good route to go down? Is that a possible route to go down for the legislation?
Yeah, I mean, it's interesting that the Liddell case is the one case that Karen didn't mention in terms of what the European Court of Human Rights has done recently. And that was a case where a person who'd been employed for a number of years as a registrar in the local authority, then when civil partnerships came in, she said from religious grounds she didn't feel that she could conscientiously participate in that. And initially, re-rostering was done so that she wouldn't have to. But then, because of objection from her colleagues, that was then said to be incompatible with the equal opportunities policy of the council, and ultimately she lost her job. And that was an example, it seems to me, and that went to the European Court of Human Rights, and yes, they said, oh, well, actually, we'll carry out this proportionality analysis, but it's the equal opportunities policy of this employer is sufficient reason for this woman to lose her job. So that's why I say we're still in the process of trying to work out this notion of reasonable accommodation. It's very much a very recent development from the European Court of Human Rights and really hasn't yet percolated through properly, I think, in the domestic courts. So the abortion issue, as you know, there's a question going to the Supreme Court on that very issue. A case of Dugan against Greater Glasgow Health Board as to the extent to which the conscientious objection in the Abortion Act, the width of its application, and whether in that particular case it can apply to nurses, midwives who are in charge, I think, of wards, although not directly involved in abortion provision. As such, they are, as it were, they see themselves as facilitating it because they are running wards at which, in which abortions are also carried out. So it's the abortion conscientious rejection was a specific carve-out for religious reasons. It's not really been tested in the courts. This case, which is coming up, will look at it a bit more. But yes, that is an example of saying that sometimes religious grounds have to be protected for individuals, which is different from the protection which we've already mentioned for religious organisations.
Thanks, Siobhan McMahon again.
I'm using the example that was put forward by yourself, Mr O'Neill, and it says, a Church of Scotland minister is also the chaplain at an NHS hospital. On Sunday he preaches in his church that marriage is only for one man and one woman. His NHS bosses find out and he is later disciplined for breaching the NHS equality policy. I understand that, Mr O'Neill, you've advised that the NHS managers would have a high chance of successfully justifying their action, even if the chaplain was preaching in his own church outside of work time. Just wondering if others share the same opinion. And if that is the case, is there something that we could put into the bill that would, obviously, we understand that things can be challenged, we accept that those things will happen, but is there something that we as a committee could put into the bill that makes that chance less?
If I may, no, I wouldn't agree with Mr O'Neill's view on that. There was quite a recent case in Trafford Housing where a gentleman who worked for the Housing Association put a comment on his personal blog on Facebook in relation to his views on same-sex marriage. Not abusive views at all, simply stating his position on it, and it was found that to then demote him and discipline him in his job was a breach of his contract, and that the employer was not entitled to look to something which was not in its terms egregious or discriminatory or harassing. It was simply a statement of his position in his private life. And you could not take that into your employment, and that case has come after, I think, Mr O'Neill's original
But what
opinion.
you're talking about is private life, whereas this is two workplaces.
It's out with his employment, I think, is the important issue, though.
Marco Biaggi in on this, please.
Yes, I wanted to ask, what material difference is it once, presumably, this bill passes and there would be same-sex marriage between saying that they don't agree with marriage and saying, for example, homosexuality is sinful, which I assume a lot of NHS chaplains would do at the moment, given the equality duty?
Lynn Welsh, would you like to answer that?
I think what you're trying to say is, does it matter what the comment actually is, as opposed to your right to make a comment?
At present, I imagine there are probably NHS chaplains that would get up on a Sunday and say that homosexuality is sinful. Are they in the same position right now as they would be after the legalisation of same-sex marriage if they got up and said same-sex marriage shouldn't be allowed? Is it the case that this is irrespective of the bill?
Yes, my view is yes.
Yes, I agree.
Yes. Yeah. They are allowed to say what their religion's view on this issue is, and that won't change because of this legislation.
Would Karen Monaghan like to comment?
Just that I agree with Lynn. I mean, there's, as I've said before, there's carve-outs in the Equality Act which would protect a minister in that position. There would be no obligation to change in the context of a church. In the workplace, things might be different, but certainly within the scope of ministering a church, there would be no difference at all. And Article 9 would offer very significant protection in that respect.
Mr O'Neill.
Every case depends on its facts, so we can always come up with a new case and say there is an issue, but there clearly is an issue. The idea of what you see outside the workplace is not divorced from what can be done in the workplace. In the Smith case, the Trafford Housing case just mentioned, the man was demoted for saying equal marriage a step too far, question mark on his Facebook. And he never got his job back. His only remedy was something like 4 weeks notice pay, and he's still on that demoted position. In terms of NHS chaplains, the case of Ladele from the European Court appears to say, well, the idea of equal opportunities within the workplace is so important that it can result in people who don't fit in with that ethos being no longer, unless they want to change their views, no longer welcome within the workplace. So it is most definitely a tension, but each case will depend on its facts, but you can't isolate what happens outside. Sorry, I haven't finished. You can't isolate what happens outside the workplace from how one might be treated within the workplace.
Just to look at the specific question, I'm sorry, the situation of an NHS chaplain at the moment who got up on a Sunday and said that homosexuality was sinful, would they at present be subject to the same potential problems that you advised would be a problem if they got up after same-sex marriage was legalised and said that it was unacceptable?
I mean, that's a particular legal issue. From the point of view, you could say, well, they're in that situation anyway. The employers would already have an equal opportunities policy and the like. But one thing that does change, however, is, as I've said, that there is a wiggle room at the moment on the basis that one can say that under European Convention jurisprudence, favouring opposite-sex marriage is permitted. But if you were to equalise and allow for marriage regardless of gender or sex, then they have to be treated in exactly the same way. So therefore it does in fact strengthen the position and change the position, strengthen the position for employers' equal opportunities policy and weakens such arguments that a minister might have in those circumstances. So there is a definite change now.
Thank you, Mr O'Neill. And we'll move on to the next question, which will be asked by John Finney.
Thank you, Convener. I was going to ask about Article 9, freedom of thought, conscience and religion, and much of it's been covered. I just wonder if I can pick up on, and it's something, Mr O'Neill, you had said previously, relating to those with conscientious objections, in particular aspects have been touched on about chaplains, foster carers, teachers, registrars, religious groups wishing to use public facilities. Is that an unfettered, unlimited discretion that would be afforded an individual regarding what they say are the religious beliefs?
As in, can anybody say whatever they want because they say that's what my religion tells me? Yeah, I mean, that's why this notion of reasonable accommodation comes in. Clearly there are understood to be limits. I mean, it's clear from Article 9 that you can limit manifestation of religion if it's in accordance with the needs of a democratic society and the like. So one can, as a result, justify in convention terms what's called hate speech, for example, which is speech which is specifically aimed at in order to whip up hatred against a particular group. So it's not an unlimited right, most certainly not.
Accepting that lawyers don't like to be given scenarios and give a definitive position necessarily on it, can I ask, would there be a limit, for instance, to the range of people who could apply that as a conscience issue? Could, for instance, a local authority painter and decorator say, I don't want to decorate that room because that room is used for that? Would that be a reasonable accommodation, do you imagine?
Well, it very much depends on facts, but I was saying that there's a case 2 weeks ago from New Mexico involving a photography studio that was phoned up and asked if they would cover a wedding, and they said, of course we will. And then he said, it's a same-sex wedding, and they said, I don't think we're going to, I think we're suddenly busy that day. And so that issue was taken to the Supreme Court, and it was found to be unlawful on the part of the photographers, that they had to offer their services, even if although they had religiously based objections to same-sex marriage, that they couldn't discriminate on those grounds. So things depend very much, as I say, on the particular facts, and it could well be that a painter and decorator would fall out with the reasonable range of those who can expect an exception from the law, perhaps.
The issue of abortion has been alluded to, and the term reasonable accommodation. I represent a very large landward area where there are challenges with the delivery of public services, and there are a limited number of people to do that. Is that a factor you imagine that could be taken into account?
As
in determining whether a reasonable accommodation should be made?
As in there are too many people potentially objecting to carrying out abortions?
Well, I was thinking more in relation to registrars and this legislation.
Oh, sorry. That we have to carry out this service and we're not able to because we don't have the people. Is that because
no, if for argument's sake there were people who were claiming that it was a conscientious objection and they were registrars and they weren't prepared to do it, there would be challenges to delivering that service in the Highlands and Islands.
Well, I mean, again, everything depends on the facts, but that would be an issue. If all these people have conscientious objections, then it might well be you'd have to fly in registrars from you know the central belt for the occasional mass same-sex wedding. I mean, I'm not quite sure, but we'll just have to see what happens. But if the fact is, I mean, if you consider individual conscience as an important value which ought to be respected, even if you disagree with it, then what is reasonable will, might well involve things like that.
Okay, I wonder, could I ask the panel, generally, the Law Society, and this was touched on earlier, but it's just the general phrase, if I may please, it's almost been said by a number of our witnesses that that could be open to challenge. It's certainly the case that anything could be open to challenge, but whether that challenge is reasonable rather than frivolous might be the issue.
I mean, anybody can go to court and challenge anything at all. And I suspect Aidan and I have done that ourselves occasionally. But it doesn't mean it's going to be successful. And so really, ultimately, some of the questions that we've both been asked from time to time don't really help the debate, because we can always construct an argument one way or another, but the real question is whether or not they'll succeed. And I think many of the objections to same-sex marriage, relying on legal arguments put together by various people, don't help us very much, because in all probability they'd be unsuccessful.
Okay. Thank you very much.
Thank you very much. Can I now actually suspend the meeting? Oh, sorry, Marco, do you want to? Yes. Sorry, sorry, I apologise for that. I didn't know we had other people coming in. Can we have Marco Biaggi and then John Mason quickly?
Yeah, I've got two more potential scenarios, which I'm really just interested in how the bill would work. One concerns transgender young people who at the moment can essentially live as transgender, can have the change in their life, live as the other gender, but they wouldn't be able to get the formal recognition until the age of 16, until the age of 18, sorry, from a gender recognition certificate, whereas a non-transgender young person could get it at 16 and would be able to marry, participate in all of this. Is there a potential issue there in terms of less favourable treatment?
Yes, probably. And it would require justification, but certainly there would be a potential discrimination claim. The question whether it could be justified would depend on things like, is transgenderism something that takes a level of maturity to 18, for example, to be clear about in an individual? I don't know the answer to that question, but certainly it potentially will violate the Convention, Article 8, for example, and it would require justification if it were to be lawful.
And I see nodding
yes,
there.
We would agree,
that's an agreement, right. The other area was in a situation where a church or a faith organisation has decided not to opt in, but has a plurality of views within its celebrants. Could a celebrant, rather than leaving their church to perform same-sex marriages, challenge their church's decision as being a violation of their personal religious rights?
In my view, no. Not if the complaint is with the church's position. That would be a matter for the church itself internally. It's entitled to regulate its own affairs as a matter of Convention Law, Article 9, and domestically. So in my view, no.
I would agree.
Mr. O'Neill?
For once, Karen and I are the one on that one. Absolutely, it's not for the state to interfere in internal church affairs. And there's specific case law from the European Court of Human Rights that says that you do not side with dissenters. If they want to dissent, they leave the church and set up their own church or join a body which is more sympathetic to their views.
Thank you.
Thank you. John Mason.
Thanks very much. It's already been mentioned, Ms Welsh, that the Equality and Human Rights Commission did not answer question 12, which was, would you like to comment on the wider issues of protection for those in society who may have concerns about same-sex marriage? You did say that you had considered all sides of this. Can I just ask why you didn't answer question 12?
I think we thought we had already answered in making clear that we were in favour of the bill as long as churches and religious bodies were fully protected. And that had been answered in another part of, of our response.
Right, thanks very much. And my other point was, there's been reference made to the Lord Advocate's guidelines, which I think came out in June, and I really wanted guidance from yourselves as legal experts as to what weight we should give that guidance, because in my understanding as an accountant, guidance could change tomorrow. So should we give it any weight at all? And how definite is it? There's a phrase within it that says, views expressed or comments made in relation to same-sex marriage in ways which do not incite hatred or violence towards a particular person or group of people will not be subject of criminal prosecution. But the very phrase inciting hatred strikes me as quite a vague one, but maybe you could guide us as to whether that is actually a more solid phrase.
I don't know the guidance, I'm afraid.
Right.
So I can't discuss that specifically. Certainly hatred is a strong word, but I'm afraid I'm not familiar with the guidance, and I'm not sure I can answer that.
Guidance as a general principle, how much weight does it have?
Well, if it's non-statutory guidance promulgated by the Law Society or some other similar body, it doesn't carry any weight at all. So, I mean, it's a view. It might guide the professionals within the particular profession, give them some help about how to approach the law. But insofar as reaching a final decision as to the meaning of any particular law, it's going to be no more than, you know, a helpful way into it. It's not going to carry any weight particularly.
Thank you.
Yeah, it's different with the Lord Advocate because the Lord Advocate has a monopoly on prosecutions effectively in Scotland. So although the courts never review what the Lord Advocate does, so as you say, the Lord Advocate can change the guidance. And I don't think it'd be, you'd have great success in saying you can't prosecute me because it's contrary to your guidance, because that would involve a civil law judicial review kind of function, and the courts in Scotland very much traditionally stand back, and if the Lord Advocate thinks it's in the public interest, then that's the Lord Advocate's prerogative. It is, but I must say it is slightly interesting, to say the least, that the Lord Advocate felt he had to actually produce guidance on an issue about what you can say in public about same-sex marriage, that it might actually be a criminal offence. I mean, to an extent, that's an issue from our incredibly broad notions of breach of the peace, what constitutes breach of the peace, and insulting behaviour. Somebody can feel insulted by somebody else's conscientious views. But yeah, I mean, Karen's correct. I don't see the courts enforcing that guidance, and it's very much at the discretion of the Lord Advocate.
Welsh.
I was just going to add that I think it does have some value in that it makes clear the Lord Advocate's view of when the powers that he and his office have should be used. So although he may not be able to be tied to them if ever they were to be challenged, I think they are helpful in setting out at least where he thinks his powers would be used. Thank you. And Christian Allard?
Yes, just a brief question. I would like some reassurance. We had a lot of witnesses coming through, and there is more evidence giving today. It's my impression that a lot of the evidence, a lot of the answers are around the Equality Act more than the bill itself. Do you think that, do you share my views? Do you think that whatever happens if the bill goes through, doesn't go through, the same question, the same challenges will still happen?
In relation to challenging, sorry, I'm not sure I'm understanding the question. If the bill doesn't go through,
if the bill doesn't go through, will we have still the same challenges that we talked about today? You know, because a lot of the examples we're giving today were challenges not towards the bill, but towards other.
Yes, they will. Yes.
So in fact, we waste a lot of our time talking about the Equality Act.
Probably. I hope not, but.
Mr O'Neill.
Yeah, I mean, that's right. We are talking, this is really about the Equality Act, and equal opportunities is a reserved matter. And although there is I do think the change of allowing gender-neutral marriage does actually change things in the ways I've said in terms of removing the wiggle room, but these are issues which are there because of the Equality Act primarily.
Okay, thank you. Does anyone else have any questions? No. No. Thank you very much for your contributions. I'll now suspend the meeting to allow witnesses to change places. Thank you. Waiting on everybody. Yeah. Welcome to our witness for the second set of questions today. Can I ask you to begin by introducing yourself?
Sure. I'm Professor John Curtis from both Strathclyde University and Scots Sense Social Research, but I should say that I am not representing either organisation, and any views that I expressed this morning are mine and should not be attributed to either of those two organisations.
Thank you very much, Professor Curtis. Can I ask Marco Biagio to start questioning?
Thank you for the unexpected honour. You've highlighted the rather substantial change in public attitudes towards homosexuality more broadly. Are you aware of how that compares with other countries? Because it has been,
short answer, as a degree of expertise, no. As a longer answer, my understanding is that it's not particularly exceptional, and obviously you would have heard the evidence from Dr. Kelly Coleman that shows that there has been a substantial international move in this direction, and one would presume that that was not done entirely in the teeth of public opinion in the countries concerned.
Have you seen any similar changes in other areas in terms of their magnitude?
Yes, the biggest change in public attitudes in Great Britain since the early 1980s is in attitudes towards our banks, which in the early 1980s about 90% of people trusted, and now only about 10% people do. That's probably the biggest. However, that aside, the principal secular change, by which I mean a change that's kept on pretty much going in a consistent direction during that 30-year period, has essentially been in the area of sexual mores. So as well as being changes in attitudes towards same-sex relationships, there's undoubtedly been a substantial change in attitudes towards sex outside marriage, particularly premarital sex. There's also been changes in attitudes towards abortion. So there's part of a more general apparent liberalising trend in attitudes towards sexual mores, which British society has experienced. Not all of those have gone at the same pace, but they've all been going in the same direction. It seems to be part and parcel of a similar liberal phenomenon whereby society has taken a very different view about these things than it did a relatively short time ago.
A quantitative methods 101 question. Which is more accurately representative of Scottish public opinion? An open website published Scottish Government consultation or a properly weighted scientific study like the ones that you're quoting?
Well, I noted the terms of your question, which I suspect not everybody would agree with. I think I would answer it as this. I think if anybody thinks that the purpose of a consultation is to find out the balance of public opinion, then they, I think, don't understand the value of a consultation. The value of a consultation, in my view, is to come to some understanding, A, of the arguments that people put forward on both sides, which you may not necessarily get out of a survey, and B, in particular, to perhaps uncover possible technical difficulties and objections to the detail of a bill that civil servants or their ministerial colleagues may not have understood. I think it's a degree to be regretted that both with respect to this consultation and indeed, for example, the consultations over the referendum, that there's been a tendency by protagonists on both sides of the debate to try and encourage people to send in standard replies, which I think, frankly, add no value at all to this kind of exercise. So to that extent, at least, I think my response to you is you shouldn't be looking to consultations as a way of understanding the balance of public opinion, as opposed to understanding the structure of public opinion and possible technical difficulties with any particular form of legislation.
Okay. Thank you for that. Can we move on to John Mason?
Thanks so much, Convener. I mean, I think you're very respected, Mr. Curtis, by many of us, as well as by the public, in your understanding of how all of this is done. Could you just give us some comments on the whole idea of you know, you kind of soften people up with questions and then you ask the big question. So how you ask questions makes a big difference to the result you get on your key question.
Well, yeah, I mean, any survey researcher is extremely sensitive to the possibility that the context within which a question is asked, and the way in which the question is phrased can affect the wording. And I've tried to be quite open with you in my submission by giving an indication of the way in which differences in question wording can make a difference. Absolutely. And I mean, if we were to go into the detail of some of these things, I think some of these questions are worded better than others, though I'm not aware, or at least in terms of things that have been done by certainly British Scottish Social Attitudes, we certainly try very, very carefully to avoid creating a context that leads in one direction or another, because our wish, at least, we may not always succeed, but our wish, at least, is to understand public opinion as accurately as possible. It's not to promote what one calls another. Clearly, some of the other questions that I put on here have been commissioned by one side or another, and one may feel that they may or may not have, as a result, begotten the answers that they were looking for. Absolutely. I mean, at the end, as you will see, in the end, you have to kind of make a judgment. And I think the first thing one needs to say is that we don't have a fantastic amount of evidence in this area. It's not an area which has been polled intensively. And particularly, certainly so far as attitudes in Scotland in particular is concerned, but it seems to me that the broad, given a variety of question wordings and look at the evidence across the piece, it looks as though, that simply asking people, should same-sex marriage happen or not, it looks as though there's a majority in favour, though I don't think it's necessarily an overwhelming majority in favour. And that, yes, it may well be true beyond that, that if you ask people to choose between same-sex marriage, civil partnership and doing nothing, it may not be the case that that a majority of people would take the introduction of same-sex marriage as their first choice, but that equally it also then seems to me from follow-up questions pretty clear that many of those for whom civil partnerships may be their first preference are not necessarily particularly opposed to the idea of same-sex marriage. So I think, and that's just an attempt to come with a reasonable judgment of where public opinion seems to be at, given the right of opinion. I mean, the only thing I would then also say is, given the very strong relationship between age and attitudes towards same-sex relationships, given also that it's clear that each new generation of adults as they enter adulthood have been consistently more liberal on this subject than their predecessors, that unless something dramatic happens in this area, some event happens, such as happened certainly in the 1980s, it is a reasonable supposition that probably public opinion is going to become more liberal on this subject in the future, and that therefore, even if one may have an argument, even if one may have question marks about both how big and how firm that majority is at the moment, it is probably only going to become bigger and firmer over the course of time.
Mm-hmm. Yeah, and in that respect, I mean, you draw the kind of parallel that as society has become less religious, or people have attended religious services or whatever less often, that society has also become more liberal. I mean, do you see these two, has there been research done as to these two are connected to each other, that it's because people are going less to church that they've become more liberal?
Yes, I know. I mean, it's perfectly clear, as you can see from some of my evidence, that those who are regular attenders at a religious service are more likely to take a conservative view on these subjects. It's also clear that, as I point out in my evidence, that difference has widened. So if you go back to the 1980s, the attitudes of secular Scotland/Britain and the attitudes of religious Scotland/Britain were rather similar to each other. So the secularisation, so the liberalisation of attitudes has occurred predominantly on the secular end of Scottish society, though that said, as I point out, it also seems to be the case that even amongst regular worshippers, there has been something of a liberalisation of attitudes. So it seems to me pretty clear that, indeed, the decline of religion observance is undoubtedly one of the reasons why our society has become more liberal. It also seems pretty clear that attendance at religious services and at religious organisations, many of whom adopt a conservative stance on these issues, does indeed seem to help to frame people's attitudes. I mean, the other liberalising thing that's going on, of course, I'm afraid, is the expansion of university education. It's also very clear, I haven't made this in the submission, but those with relatively high educational qualifications tend to be more liberal on these subjects than those with no educational qualifications at all, and therefore it's become a better educated society. That does tend to encourage social liberalism, things being equal, and that's another phenomenon that's tended to push our society in this direction.
Okay, thanks. On you go. Just a minor point. It was just, I didn't quite understand in paragraph 16 of the submission, line 5, I saw independence had crept in. I hadn't really expected independence as part of this. I don't know if...
No, I'm sorry. Thank you. That's that's another error. You can imagine what else I was thinking about as I was writing the submission. It should read same-sex marriage. And actually, while you've asked that, I should also say for the record at paragraph 3, penultimate line, for they same, you should read that same. And at paragraph 10, line 5, after the word religious, insert the word service, and then hopefully we've caught all the typographical errors.
That's great. I mean, I knew independence wasn't a lot of our minds, but I hadn't expected it here. Thank you.
Before I hand over to Alex Johnson, can I ask a very quick question, Professor Curtis? Is there any evidence that attitudes within the religious organisations, within the clergy, are becoming more liberal?
We don't have enough members of the clergy, anybody in any kind of religious order, to know the answer to that question, okay? What we do know is that, which kind of, if you wanted slightly more colour, is that there is a difference between members of different religious denominations, stroke religions, and that certainly the section of Scottish society which seems to be most conservative on this subject is perhaps contrary to the general impression, those of a Presbyterian faith, particularly it seems amongst those Presbyterians outside the Church of Scotland. The numbers are relatively small, and we therefore have to be careful, but probably Episcopalians are probably towards the liberal end of the spectrum, with Catholics somewhere in between.
Okay, thank you. Can I bring in Alex Johnson?
You know, sometimes in politics, you know what you're going to say next, but you just can't help yourself. So I'm going to take John Curtis on an issue in which he can, I'm sure, quite easily make a fool of me, but I'm going to try it anyway. You were talking about the liberalisation of views. Yeah. And I fully accept that the information you quoted is the case, that views are becoming more liberal, and when they're polled, that information is very obvious. But what I want to just look a little bit deeper into that. What do the public themselves think about liberalisation? What is their motive? You know, is there an increased tendency over time for people to just go with the flow? Is it a deliberate action, or is it a simple?
Well, I think my answer to you, Mr. Johnson, is that again, just remind yourself of what public opinion was in the mid-1980s. The idea that that we as a society have, in some sense, gone with the flow is very difficult to believe, given the degree to which, you know, a little more than 25 years ago, as a society, we pretty much unanimously adopted a critical attitude towards same-sex relationships. It looks to me very much as though there has been a genuine, quite dramatic, but substantial change in attitudes, which in a sense has been society not going with the flow. Society's reversed itself. Yep. It's very difficult to see how we can say, you know. Is it? I mean, what of course, let me just add that, what then of course is true is that, I mean, those people of my generation, right? I mean, I can remember when male same-sex relationships were still illegal, okay? And it's undoubtedly true that certainly those of older generations, their views have changed over time, and one suspects almost undoubtedly that their views have changed over time as a result, in part, of being influenced by the greater liberal views of, for example, their own children. Equally, for example, I think is almost undoubtedly the case, the views of many older people with regard to cohabitation and heterosexual relationships outside marriage have again been changed as a result of the behaviour of their own children. So to that extent, yes, there is, I mean, as attitudes have begun to change, then for those who, as it were, of generations for whom this was not the norm, then undoubtedly I think they've reacted probably to social pressure. But I mean, that's just people changing their views because they see the world changing. I mean, I don't think it in any way is kind of undercuts the reality of the change that we've witnessed.
But is the liberalisation of views genuinely because people at large care more about these issues and want to deliberately change their position, or is it perhaps that people simply care less?
Well, I think the answer to that is I certainly would accept that I think it is probably true, and this is now an interpretation on my part of the data, it is probably true that most people who say, no, there's rarely or nothing wrong with same-sex relationships, they're not necessarily saying that this is something that they think is something they feel very strongly about, as opposed to what's all the fuss about?
Yes.
Why are we worrying about this? Of course it's fine. And that certainly, therefore, there's probably almost an asymmetry of feeling about this. I think it's probably true that those who feel that same-sex relationships are wrong, let alone are opposed to marriage, probably feel that view more intensely than many of those people who adopt the opposite view. And to that extent, you know, we've got an asymmetry of passion on this debate. And I think it's also probably true that it's not true that the vast majority of people in Scotland and Britain are thinking that changing the law in this area is some major priority. But it's simply, if it's going to happen, that's fine. Yeah. Why didn't we do it a few years ago?
Yeah, that's what I meant by the phrase "go with the flow." Is that?
Well, I think it's misunderstanding going with the flow, because I think the point is, this is not to say that the attitude isn't held. I mean, I think the point is, I think what I'm saying to you is, I think the view of most people is, what are you on about? What's the issue? Literally, what's the issue here? So the difference is, so when we're talking about independence, most people understand there's an issue here, that there's a real choice here that matters, and that people can understand why some people might be for and some people might be against. I suspect in this area, people's views have changed such that many people are just saying, oh, you mean there's an issue? And in a sense, and that's probably particularly true of younger people, because they've grown up in a society where the predominant view has been in recent years that same-sex relationships are okay, they are probably wondering what some older people are arguing about, because the norm very much amongst younger people undoubtedly is fine, whatever, okay? So I don't think you should I think you should therefore, I think it therefore follows that for certainly those who are passionately arguing in favour of this bill, as it were, they have a problem in the sense that I don't think there are many people like them who are passionately arguing for this bill, okay? But equally, I don't think you should take the view that if the majority of the public are saying, yeah, okay, that's going to happen, that's fine, yeah, maybe that's indeed what we should be doing, that you therefore should necessarily presume that's an argument for ignoring public opinion. But I think if you're going to ignore public opinion on this issue, you have to come up, exactly this, public opinion on the death penalty has, although it's now begun to change, has long been in favour of restoring the death penalty. Now, many a legislator would say, okay, I can think of an ethical argument why on this occasion I'm not going to follow public opinion, okay? I think, given that the role of legislators is, other things being equal, to take serious cognizance of what public opinion thinks, if you're going to say, no, we're not going to follow public opinion in this area, and if you accept my reading of public opinion, then you have to come up with ethical arguments as to why following the public view is not necessarily in the public interest.
Thank you very much.
Can I bring Marco Biaggi in?
Yes, you referred to a series of variables that predict people's attitudes towards same-sex marriage in the written submission, namely age and church attendance, and you've already alluded to level of education being another one which wasn't in the written submission. Is there anything else that's statistically significant?
Gender, men are usually less liberal than women on the subject.
And those are the only things that have been found through the interrogation?
Yeah, you can look up the full detail. There have been various reports done for the Scottish Government more generally about attitudes towards discrimination. But essentially the crucial ones in this area are gender, age, education and religious observance, basically.
Once you control for everything else, is there an urban-rural divide?
I'd have to go back and recheck the data. I'm quite happy to do so. But it's a little while since I've engaged with the data at that kind of level.
I think that's probably more for my curiosity than Bill's.
I would simply remind you this is a predominantly urban society, albeit it has a very distinctive rural hinterland.
Can I ask Siobhan McMahon to ask questions?
Thank you, Professor Curtis. On what you've said previously, you've described, people getting more liberal and seeing it maybe not as the priority, but what's the fuss about it. I was just wondering if there was any evidence or any studies that you're aware of that the committee can look at that has drilled down to not simply the question of is same-sex marriage, should it happen, yes or no, but the consequences of that and other protections or freedoms that we discussed in previous panels?
I think the honest truth is I'm not aware of anybody trying to engage public opinion there. I mean, the only thing I can point you to in my evidence that will give you some guidance is the Murray question, which I referred to at paragraph 15, which is the only poll that I'm aware of that either north or south of the border, which drew the distinction between religious marriage and civil marriage, all right? And it seems pretty clear from that it's civil marriage that people think that the majority think should be legislated for rather than religious marriage. I think, but I would have to check, that there may be the odd question on surveys Britain-wide during the course of the passage of the equivalent legislation at Westminster that probably indicated that. I'm pretty sure that you get a majority of people saying, yeah, no, you shouldn't force religious organisations to perform marriage ceremonies if you don't want to. But I mean, I think you will appreciate, shall we say, some of the conversation that I heard coming towards just before this session is going to go way above the heads of the average person, we cannot ask in surveys detailed legal arguments as opposed to the principle of whether or not somebody should or should not be required to do something.
Okay,
but if you want me to check that, I mean, just get the committee clerk to write me, and I'll happily check through the data file that I've got.
Thank you.
Thank you, Professor Curtis. Does any other members have any other questions? John Mason.
Yeah, well, I've got a wee bit of time. I mean, you made the point that there's a kind of more liberal move throughout society, I think. And I mean, you did specifically mention capital punishment. I mean, is that one where society is changing as well?
Yes. I was just looking at the evidence. So this is UK-wide data. Support for keeping having the death penalty is now down below 50%. It's somewhere in the 40s. Right. So that's also now something where attitudes have become somewhat more liberal. So I mean, the one thing where as a society we have definitely not become more liberal. If anything, we've actually become more conservative, if that's the right word. Is actually people who have a regular sexual partner then having sexual relationships with somebody else. In other words, infidelity is something in society which, if anything now in society, we're even more critical of. So it's not necessarily the case that when we're talking about liberalising, about sexual mores, it's not the case in society that we think anything goes. And for the most part, we certainly seem to be in favour of monogamous relationships at any one point in time. It's simply that we simply have become much more relaxed about, A, whether it takes place within marriage at all right? And secondly, we've become much more relaxed about the genders of the person who engaged in the activity. I mean, I think one thing, obviously, the committee must be aware of this, that, there's a certain irony about this legislation, which is that we are talking about enabling those involved in same-sex relationships to enter an institution which relatively large sections of the heterosexual community are no longer getting involved in. And where society no longer necessarily thinks that sexual relationships is something that should necessarily take place within marriage. And again, that's an area which is also part of the liberalising trend of the last 25 years.
But I was interested in your comment about monogamy, that actually your feeling is that society is still supporting.
Very, very clear. I refer you to the British Social Report, and I think I make some reference to it. I give you the reference at paragraph 17 of my evidence. We are very, very definitely. I mean, it's almost a sense now that because people's views seem to be that what matters is your partner, all right, and the quality and the nature of your relationship, that's what now seems to matter to people, rather than sense of obligation, let alone some religious teaching. Therefore, as a result, cheating on your partner is, if anything, now regarded even less acceptable, because we now value the quality of the relationship, but more than we do the formal institutional position.
That's very interesting. Right, thank you.
Thank you. Alex Johnson.
We've heard the words liberalisation and conservative approach used in their true sense, nothing to do with the political parties.
So there's no normative
indeed. However, my instinct is that in reality neither description describes how I have for most of my life dealt with the issues surrounding this and similar issues. The word that I would use, and which actually hasn't appeared during the evidence we've taken so far on committee, is tolerance. It's about tolerance of the differences, the different choices that people make, and learning to not impose my views on other individuals or to see people through that prism. Do you think, in the way that you've assessed public opinion, that during the course of the period when opinion has become more liberalised, has Scotland become more or less tolerant?
Well, first of all, I'm happy to accept the word tolerant. Secondly, I mean, as I've pointed out, we have much less in the way of evidence on this north of the border. But, well, I mean, two points to make. I mean, since 1999, since the period since we've had Scottish tattoos, and therefore we've had some evidence in this area, it's pretty, I mean, you know, as you've seen from the evidence on attitudes towards same-sex relationships, you know, Scotland has largely looked as though shared in the liberalising stroke, more tolerant trend. So that's point one. Point two to make is that whereas even in late 1999, even 1999-2000, it remained the case that Scotland was a more religious society in terms of levels of religious attendance than was England and Wales. That's no longer the case. And in fact, now, I mean, it's not just in this area. I mean, as you said, one of the key things I'm arguing in my evidence is that essentially attitudes in Scotland are very similar to those south of the border. And that indeed, a whole load of other areas, and I can happily send you the chapter if you want, basically in terms of, you know, these areas of kind of, you know, social issues, Scotland and England and Wales now look very, very similar to each other, which inevitably raises the issue, I think, for this institution. Given that at the end of the day, England and Wales has legislated first in this area, again, I think you would have to come up with good reasons, given the similarity of outlooks on the two sides of the border, as to why Scotland should adopt a different perspective.
When I compare the concept of liberalisation with the concept of tolerance, you know, I perceive a difference, and I perceive differences in a number of ways. But one is that while society as a whole becomes more liberal, tolerance and intolerance is something that has changed quite radically within those who hold strong views. For example, I find that those who seek greater tolerance are themselves likely to be the least tolerant of those who don't share their views. Do you think there is a... Basically, what I'm suggesting is that tolerance is a one-way street now.
Yeah, I mean, clearly, clearly, the difficulty with this issue is that we're talking about changing the character of an institution in which, as it happens, religious organisations have long played a significant role, and where many of those institutions do not agree with the change that's taking place. So there is inevitably here, we're talking about a political conflict, okay? You know, welcome to politics. Yeah, there is a real conflict here, and you know, you may or may not. I mean, you know, clearly there are interesting arguments to have, which kind of lie outside this committee, as to, well, you know, if society comes to believe that same-sex relationships are okay, is it or is it not acceptable to then use the force of the law to stop people from expressing those views? And we can see these debates particularly going on in the area of race relationships, and this gets onto whole arguments about what harm is or isn't done with those of minority view. I mean, my reading of opinions, I think it comes back to the question that Ms McMahon asked, is that, you know, again, is that it's not clear at the moment that as a society we wish to force this change, if that's the right word, down the throats of the religious organisations who do not wish to follow down this path. That seems to be the position from, the evidence, particularly in paragraph 15. And to that extent, at least, yes, we seem to be tolerant rather than liberal, or i.e., most people seem to be willing to accept, well, if that's what you feel, okay, right? And that we're not necessarily willing to use the law in order to force organisations to do something. I think it's an interesting question, given that society is liberalising, and given that there is evidence that gradually attitudes, even amongst those who are regular attenders of religion, their views are liberalising, whether or not in 20 years' time we will discover that most religious organisations have decided to take advantage of the legislation that allows them to perform religious ceremonies. And I suspect, in truth, in terms of, given we're talking here about trying to manage a very dramatic social change, all right, and again, I think was now trying to think about what's good for society. Given we're talking about a very dramatic social change in which there is a section of society that now finds themselves living in a climate which is very different from what they are used to and what they themselves believe, it clearly, I think, is in the interest of that society to manage that change in such a way that minimises conflict. I think you as legislators want to do that. So to that extent, at least, having tolerance as your watchword in this area is probably, insofar as it can be pursued, given there is some genuine conflict here, probably a good mantra to follow. Thank you.
Thank you very much. Does any other members have any more questions they'd like to ask Professor Curtis? No. Professor Curtis, thank you very much for coming along. That concludes today's meeting. Our next meeting will take place on Thursday, the 26th of September, and will include further oral evidence on the Marriage and Civil Partnership Bill. Thank you.